So, what is land use regulation essentially trying to accomplish? Well, what it is essentially restriction on property owners as to what they can do with the land that they own. Now, we talked about private property rights being an essential component for the success of market based capitalist systems. And this seems to be somewhat of a violation of that, in that someone owns property and yet they are kind of restricted as to what they can do with it. And of course, we live in the real world, and not everyone is just going to kind of bow to the whims of whatever norms exist. So, in order to actually implement land use regulation, there had to have been a set of laws that were passed, and with laws, the enforceability of kind of the state police and judicial apparatus to kind of get people to comply with this idea of regulating land use. So it was not just a matter of telling people, hey, you can do this or you can do that. Uh, the enforcement of land use regulation needed the teeth of the law and the state to kind of actually make it work. So, land use regulation involves law from all levels of government, but most acutely, the laws at the state and local level are going to be the ones that are most relevant for land use because really each city is going to have their own zoning ordinances, and the state, of course, can overrule or pass laws that kind of override the local level government. This is just how our kind of federal system of government works, where we have kind of different levels of government, where the higher up level, so if you're a city government, the higher up level is going to be the county and then the state, and then the state can technically be overridden by the federal government, which can pass laws that restrict the states. But of course, the federal government is also bound by the Constitution and the enumerated powers that the Constitution says, like, hey, the federal government, its wheelhouse is only X, Y, Z things. But really, the state, unless it's bound by the state constitution, has a lot of power over local governments. But really, when it comes down to it, when you're actually a property owner trying to maybe develop your property or use it for some use that you want, you're going to be dealing with the local level government, the city, and sometimes the county, and the different laws and regulations that exist at that level. Now, there are a number of cases and laws that are relevant. I'm just going to talk about two here. The first is the Standard State Zoning Enabling Act of 1922. So, this was a federal law that was passed that kind of set the framework for local governments to have zoning regulation in the first place. This was a federal law, and kind of in the modern context, most states have enacted their own specific zoning laws that kind of are tailored to each particular state's specific legal framework, etc. But really, this federal law was the starting point and provided a kind of seed for this idea of local governments having the ability and the initiative to basically start uh, restricting the use of land using kind of zoning ordinances. An important case that kind of sprung from this was Euclid versus Ambler. And basically, it was a case where a property owner wanted to do something else with their land. The city of Euclid had already passed kind of a zoning ordinance and had zoned the city with certain uses, etc. And this property owner argued that this was a violation of their constitutional rights that were kind of protected. And they made a constitutional argument where they said basically they were not. This is an illegal taking. The government can't just seize property as per the Bill of Rights, and also kind of a due process. You have to be afforded due process, and the government can't just arbitrarily do things. So Ambler tried to make this argument that it's constitutionally protected rights were being violated by the Zoning Act that this city had passed, but they ultimately lost. And this case opened kind of the door for cities to basically compel property owners to do what was within the plan, the planning of the city and the zoning ordinances that were kind of a result of that planning that the city had done. There's another important case, Penn versus New York City, where a property owner of Penn Station in New York wanted to build a kind of a high-rise building, or significantly alter the look of Penn Station. And New York City had some laws in place to preserve kind of historical buildings. And so this case also went to the Supreme Court, and it was deemed that the basically the city did have a right to prevent that use, or that increased kind of intensity of use that the owner wanted to do. So this was another blow to kind of property owners being able to assert their property rights to do what they want to do with their land, and instead have to conform to kind of the local land use regulation. Okay, and then I'm just going to mention CEQA. It's in California, a very important law in kind of land use regulation. It stands for the California Environmental Quality Act, and basically the law requires the state and local agencies that are kind of uh, overseeing the development of real estate and any kind of projects, like even like a solar, if you want to put a solar farm somewhere out in the desert, or if you want to build a dam, or if you want to do some big project. It's not just kind of real estate development in the traditional sense, it's just any project that is altering the land use. There has to be an assessment of the environmental impact of that particular project, and it involves preparing, a lot of reports and doing studies, and kind of uh, assessing the environmental impact, and whether it's going to be whether the cost benefit of the project versus the environmental impact is going to be positive. CEQA is very controversial in the development community because it is often weaponized to prevent the kind of increased intensity of use of a property. For example, if you wanted to take a, parcel of land that has one house and put kind of a more intense use, maybe build 5 units or 8 units on it, that could potentially, you know, y- the neighbors may not like that and could use aspects of this CEQA law to prevent that development from happening, or even larger projects where you know maybe there's some animal that is its habitat is on the property. The developer wants to build maybe whatever 500 or 1,000 homes on the property, but since it's the habitat for this particular animal, uh, those aspects, or those advocates of non development, or like those interests, those special interests in the state that don't want development to happen, can use CEQA to kind of block that from happening. A lot of people say that this is why there's such a shortage of housing in California, that a lot of projects, for one, don't happen because CEQA is used to block them. And then secondly, the housing that does get built is more expensive because of all the kinds of hoops that developers have to jump through to comply with CEQA. So this is just an example of a particular regulation that maybe had very good intentions, but which had real life results that are controversial, to say the least. Because again, there are trade-offs. So the environmentalists who were kind of advocating for CEQA, to get it passed, didn't think of the spillover effects of the law. And so once it was passed, we as kind of society can see all the second order effects that are a result of this law, that were most likely unintended when the law was passed.